Emergency and Human Rights before the Inter-American Court of Human Rights. And thirdly, last April, there is a ongoing advisory proceeding before the International Court of Justice as the main judicial organ of the United Nations. The ITLOS has a special distinct challenges, not like the other ICJ and IACHL are, because there is no express provision conferring advisory jurisdiction to ITLOS under the UNCLOS and the statute of the ITLOS. That's I think the fundamental difference between the other tribunals. ICJ and IACHL has the express provision conferring the advisory jurisdiction, but not to the ITLOS. Second challenges would be that the substantive legal issues like indeterminacy of the applicable law, such as the Paris Agreement and UN framework on climate change. Most of the substantive provisions relevant to the climate change are not that determinable. So that's another point of the challenges the ITLOS has now. So due to the time restraint, I will directly go to the question submitted by the COSIS. So the question I quote, what are the specific obligations of state parties under the UNCLOS, including under Part 12, A, to prevent, reduce, and control pollution of the marine environment in relation to the deleterious effects that result or are likely to result from climate change, including through ocean warming and sea level rise and ocean acidification, which are caused by anthropogenic greenhouse gas emission into the atmosphere. B, to protect and preserve the marine environment in relation to climate change impacts, including ocean warming and sea level rise and ocean acidification. The questions are very simple, but in abstract. What is the specific legal obligation under the convention relating to the pollution of the marine environment relating to the climate change? So the reason why I gave the title to my presentation about why the ITLOS need the wisdom of the Solomon. So if the ITLOS does not recognize jurisdiction and admissibility, it could be a denial of justice. And also it could prove that ineffective implementation mechanism of the climate change law. So, and on the other hand, if ITLOS recognize jurisdiction and admissibility and give some kind of advisory opinion, but based on the second challenges of the substantive legal issues, it could be an unnecessary answer by just reaffirming the existing rules and norms under the UNCLOS, including Part 12. However, on the other side, they could give a doubtful answer just by expanding rules of reference without state parties' consent. It is directly relating to the limitation of the advisory jurisdiction of the ITLOS as a whole. So that's the main concerns raised by the scholars and practitioners about the ongoing proceedings on the climate change and international before the ITLOS. So I'd like to delve into what could be the solution, what could be the wisdom of the ITLOS to avoid such a kind of unnecessary answer or doubtful answer. This was my beginning of my question. So there was a written proceedings. So almost 35 state parties submitted a written statement about the question raised by the COSIS. And also there are many intergovernmental organizations and non-governmental organizations submitted their written statement as well. So, and as Professor Ronan Long at the very wonderful open keynote speech, he suggested that our dear colleague Nilufer Oral is participating in the oral pleadings. So from September 11 to the 25th September. So that there will be almost 2 weeks oral pleadings, and also there are many state parties are participating in the oral pleadings. So once again, I'd like to emphasize there is no express provision under the convention conferring advisory jurisdiction to the tribunal as a whole. That's the problem. And also, it could also affect, even though the ITLOS recognized the jurisdiction based on the former IUU advisory opinion, that there could be another problem. What could be the scope and extent of the jurisdiction given by the agreement of the COSIS? It could be another problem. So there are two obstacles, whether the ITLOS can recognize the jurisdiction, and then what should be the scope and extent of the jurisdiction given by the COSIS agreement. So however, ITLOS just exercised the advisory jurisdiction in the IUU fishing advisory opinion in 2015. They interpreted Article 21 of the statute. All disputes and all application and all matters also include the advisory jurisdiction. So it was very simple logic. So it was severely criticized by some of the countries and also academic circles. However, in the IUU advisory opinion, the ITLOS made some cautious approach. They delve into the question raised by the SRFC. It was a question of a legal nature. And also they had a sufficient connection with the purposes and principles of the MAC Convention. And also they just limited the scope of the jurisdiction to, in the case, to the exclusive economic zone of the SRFC member states, not beyond the EEG into the high seas. So it was a kind of some separate restrained approach taken by the ITLOS about exercising the advisory jurisdiction at the last advisory opinion. And also Article 1, I'd like to mention the Article 138 of the Rules of Tribunal. It is clearly provides some prerequisite for the advisory jurisdiction. So it should be a legal question, and also it should be an international agreement should be related to the purposes of the convention, specifically provides for the submission. And also the body is authorized by or in accordance with the agreement to make the request to the tribunal. So it is the prerequisite, and we need to check out whether the COSIS agreement is meeting the prerequisite of this in accordance with the provisions. So is that the legal question with the sufficient precision and also sufficient relationship with the purposes of the convention? To my mind, to my reading, then it is quite clear that it is a legal question and it has also sufficient relationship with the purpose of the convention. However, there are still controversy over whether isn't it the ITLOS exercising the advisory jurisdiction is the avoiding the principle of the consent of the state, because the non-parties to the COSIS agreement, they did not give the agreement to the exercising jurisdiction of advisory jurisdiction of the ITLOS. However, so ITLOS could be expanding the advisory jurisdiction to the non-parties to the COSIS agreement. So it's one of the issue. And in the written proceedings, only Brazil and China clearly state that the ITLOS cannot exercise advisory jurisdiction based on Article 21 of the statute. And also UK, Portugal, and Canada pointed out that the scope and extent of the advisory jurisdiction should be limited to obligation under Part 12, not going beyond the convention. So that was the very important points, I think. So I will skip the specific statement, but the point of the possibility of the exercise jurisdiction is boiled down to the whether the ITLOS can exercise advisory jurisdiction without violating the state consent principle. So, but when we're referring again to the IUU advisory opinion, then the ITLOS will not have many difficulty to found that they can exercise jurisdiction. However, again, the problem should be what should be the extent and scope of the jurisdiction, whether ITLOS directly apply the Paris Agreement or UNFCCC agreement to invoking some specific obligation under the convention, including Part 12. So that's the problem. And I'm going to talk about now the specific obligation of the state parties. So the main point, the second challenge is should be what should be the substantive obligation of the state parties to the UNCLOS. So the most of the written statement submitted by the state parties are almost similar. So the general provisions from the 192 to 256 or something like that, most of the provision under the Part 12 are applicable to the pollution of the marine environment caused by the climate change. So there are not a big difference, but there is a huge difference. One is that the G77 groups, especially African states, including Rwanda, they are arguing that the loss and damage issue also should be dealt with in the advisory jurisdiction. So that's the another issue of the scope of the jurisdiction, whether ITLOS can deal with such a issue. It seems like the go beyond the scope of the Part 12 of the convention. So that's one of the substantive legal issue. And the other obligation, substantive obligation, is an obligation to prevent, reduce, and control pollution caused by the climate change. And many states also submit that the obligation of due diligence relevant to climate change are applicable to the advisory opinion. However, the rules of reference also has some limitation. We are calling the generally accepted international rules and standards. So we are calling GAIRs. So what extent of the GAIRs also applicable to the advisory opinion? It should be also another problem and serious issue should be. Thank you for time checking. And the last points I'd like to mention is that there are some challenges whether the UNFCCC and Paris Agreement are applicable norms as generally recognized international rules and standards, and also relevant obligation such as open-ended commitment under the UNFCCC and NDCs on the Paris Agreement applicable to the advisory opinion. And the other problem is that there is no disagreement on the existence of obligation to mitigate climate change, but there are divergent view on the content of the obligation. That is the whether it is the temperature goal should prevail 1.5 or 2. There's no agreement, specific agreement or specific content of the obligation. So it's another challenges to be tackled by the ITLOS. So to wrap up, despite the disagreement over jurisdiction and admissibility over the advisory jurisdiction, few state parties clearly object to exercise advisory jurisdiction by ITLOS. So I just expect that ITLOS will have no difficulty to found they can exercise jurisdiction. However, the real issue should be the extent and scope of the advisory jurisdiction, whether they can go deal with the specific provision of the Paris Agreement and UNFCCC convention, such as things. So, but there could be another prospect that the state parties to the UNCLOS and intergovernmental organization will have a very good opportunity to elaborate their views and position about the specific obligation on climate change and international law during the public hearings before the ITLOS. And it could give some implication and some of the state practice and opinion jurists about the climate change to the ITLOS. And ITLOS can get a hint, but they should give us wisdom of the Solomon to answer the useful answer to the question raised by the coaches. Thank you very much for your kind attention. Thank you.
Thank you very much. Our next speaker really needs no introduction. Professor van der Zwag has been a regular speaker at these convocations really for the last 30 years continuously, and comes a long way to join us. He's Professor of Law, Canada Research Chair in Ocean Law and Governance, and Director of the Marine and Environmental Law Institute at Dalhousie University, Eastern Canada. And he is a member of the International Council of Environmental Law, as well as on the IUCN World Commission on Environmental Law. And for more than a decade, co-chaired its specialist group on oceans, coasts, and coral reefs. Has a tremendous CV, published over 150 papers in the field. I won't even start to mention them, but has long been an esteemed scholar in the field. Professor van der Zwag.
Thanks, Chris. I didn't realize how old I was. Over 30 years of participating in Law of the Sea. By the way, my introduction to Law of the Sea Institute wasn't glorious. I was an LLM student at Dalhousie in 1982, and they came in with their conference to Dalhousie in Halifax. And one of the senior advisors said, "We have a great job for you. You could be a tour guide on a bus tour. They'll take the couple bus tours around the area around Halifax." I said, "Great, a chance to meet people." And of course, the day of the bus ride is one of the foggiest days in Halifax history. And there I was as a tour guide saying, "Well, if you could look out your window to the right, on a normal day, you would see Piggy's Cove and the lighthouse, but you never could see anything." So that was my introduction to Law of the Sea. And I'll stop there. My PowerPoint there. Great. So I'm going to talk a little bit about the Arctic, and this title being, you'll see in the program already. So treating and thinning sea ice has placed the Central Arctic Ocean, obviously a large donut hole, high seas and underlying seabed on the political and public radar screen, very obviously. We have the reduction of sea ice. You see there on the left slide, the pink line is where we used to have the ice. And then in September 2012, you have a great reduction. It's been similar like that since. And then you have these different shipping routes, of course, the Northern Sea route being the one that's being used more and more today. And then the transpolar shipping route over the high Arctic, over the top of the pole. Again, that's a future thing. You're not going to see it tomorrow, but that's the prospects, and there's great interest in it. And then, of course, you have the Northwest Passage, which is more problematic to develop in the future. And then you had the Russian flag, and of course, in August 2007, the great media frenzy about the scramble for resources. And again, there will likely be a lot of mineral resources up there. So there we are. So what I'm going to quickly do is go through the cooperative currents image. 2 layers of cooperative streaming stand out. Global agreements develops relevant to the Central Arctic Ocean, marine conservation, then regional eddies, and then the murky waters. I'm going to focus on 4 uncertainties to be flagged, and a 2-part speed cruise will follow. I think I actually hold the Law of the Sea Institute Berkeley record for fastest PowerPoints, and I've broken my own record almost every year. So this year, I think it's going to even be faster. So do not blink, because I'm going to skip over particularly the first slides very quickly because of time. And again, we have Law of the Sea experts. So I think you all know what the Law of the Sea responsibilities are, but I'll go over them very quickly anyway. So first of all, obviously you have the Law of the Sea overarching framework, a mainstream. You have obviously the provisions provide guiding currents. We have freedom of the high seas, of course, applied to the Central Arctic Ocean like other regions. Flag state jurisdiction prevails as the prime principle for controlling activities very clearly. And then you have all these responsibilities. I won't bore you with all the details, but generally preserve the marine environment, concern high sea fish stocks, and cooperate with other states in seeking to manage fish stocks jointly exploited. The EIA obligation, again, for any activities may cause substantial pollution or significant harmful change in the marine environment. and protect necessary measures to protect and preserve rare fragile ecosystems and habitat of threatened or endangered species. We obviously have the right then of all coastal states, if they have extended continental margins, to claim those margins, submit it to the Commission on Limits of Continental Shelf. And of course, the coastal states then will have sedentary species rights and rights to the mineral non-living resources on those extended continental margins. Mineral exploration and exploitation obviously would come under the International Seabed Authority control in most cases. And I'll come back to that later. That's an issue in the Arctic. And then you have the UN Fish Stocks Agreement. Again, it applies, of course, calls for application precautionary ecosystem approaches, and obviously committed to establish a sub-regional regional fisheries management organization arrangement where no such organization arrangement exists for a particular straddling or highly migratory fish stock. And then we get the BBNJ agreement, and of course we have the new arrangements now on genetic resources, MPAs, and other area-based management tools, and environmental impact assessment. I'll come back to that towards the end as a major challenge. And then you have the numerous IMO agreements and guidelines. I could spend an hour and a half, 2 hours lecturing just on that. You have the Polar Shipping Code. It does cover the whole Central Arctic Ocean as well. It sets new pollution standards, of course. It came into force 2017. There's a no oil pollution discharge, a no noxious liquid substance discharge. So you have stricter standards now for most pollutants. And then you have a heavy fuel oil ban that was adopted recently, which will come into force in July 2024. Again, heavy fuel is very hard to clean up. It's a dirty fuel anyway, but it's very hard to clean up if it spills, particularly in ice-covered waters. So again, that'll cover the Central Arctic Ocean as of July 2024, with some exceptions for search and rescue vessels and oil pollution preparedness response vessels. They are given some exceptions there, they can still carry the HFO fuel. Then you have the regional current cooperative eddies. I will not have time to go into these, but you do have 3 conventions, treaties adopted at a regional basis through the Arctic Council task forces. And you have an agreement on aeronautical maritime search and rescue. If a plane goes down in the Central Arctic Ocean, a ship wreck goes in the Central Arctic Ocean, again, we know which country is going to take a lead in search and rescue, and there'll be joint recovery response. You have oil pollution preparedness and response. Again, joint cooperation there is called for. And then most recently, a scientific cooperation agreement. That's mainly about opening your borders to scientists to come across without getting all the visa problems and that kind of thing. But again, it's about sharing information that you get on cruises in the high Arctic, Central Arctic Ocean. It gets to be shared kind of openly with other countries. So there's a call there, and it does cover the Central Arctic Ocean. And then you do get some regional cooperations also on the 5 Arctic coastal states have the 1973 Polar Bear Conservation Agreement. And again, 5 states having the polar bears basically agree to protect the dens and ecosystems, prohibit takings, with a few exceptions, subsistence hunting, self-defense to save human life, scientific purposes. And then they have a circumpolar action plan adopted in 2015. Interestingly, when it was adopted, the law of the sea really was not settled yet about offshore jurisdiction. So it doesn't actually give any boundaries. It assumes that everyone's going to take care of the polar bears when they go on the high seas, but it doesn't really deal with takings on the high seas. So what happens when the hunting goes out on the high seas, eventually where it may go, there's no sharing formula under the agreement. And then what happens if China takes a polar bear to a Beijing zoo? Again, I'll leave you to think about that. If I had more time, I'll get into what would be the answer. And then basically you also have then the broader Arctic 5+5 regional cooperation on Central Arctic Ocean fisheries. Again, most people probably are aware of this agreement adopted in 2018. It now involves the Arctic 5 coastal states, China, Japan, South Korea, Iceland, EU. And you have various commitments now, not authorizing flag vessels to conduct commercial fishing in this area unless conservation and management measures have been adopted by one or more regional fisheries or sub-regional fishery management organization arrangements pursuant to interim measures that may be adopted by parties under the agreement. They agreed to establish within 3 years of entering the agreement an exploratory fishing protocol. When fishing want to go out and explore, what are the rules on that? And within 2 years, they're supposed to develop a joint program of scientific research and monitoring and a data sharing protocol. They're going to be convening at least every 2 years to review implementation and consider whether to commence negotiations to establish one or more regional fisheries management organizations or arrangements. It entered into force in June 2021, and it has been able to survive the Ukraine crisis. The Arctic Council a regional forum for discussion had a pause, and they did not want to have Russia invited. And so they put a pause on it. Some of the working groups have now begun to work on some projects again. But actually, the fisheries agreement actually held a couple of meetings already of Conference of the Parties. First one in November 2022 in person, and the second one in June 2023. And again, I think it's partly because of South Korea, actually, believe it or not. South Korea has hosted these meetings. It's kind of a neutral country. You would probably not be able to hold it in the US, not in Canada, given the politics. And a framework for a joint program of scientific research monitoring and data sharing were adopted at the June 2023 meeting. So there's been progress under the agreement. And then you do get the Northeast Atlantic Fisheries Commission. Because of time, I won't go into details, but they do have some provisions already. For example, you're not allowed to go and direct fishery for deep sea sharks in that area, way up in the, should be up in the sector up there in the Arctic. And they also have an exploratory fishing protocol. You have to have environmental assessment before you go out into the upper area in the Arctic. Murky waters. So I think I have what, 8 minutes? This is going to really be a record then. So murky waters, 4 flag quickly. Sorting out the future of Central Arctic Ocean fisheries governance. So all kinds of implementation problems here. Working out the scientific cooperation details. They're going to have an implementation plan that they hope to have by next year, 2024. But, you know, are you going to have enough money, human resources, ship times, very expensive to go up there. It remains to be seen whether countries will ante up. Clarifying the conditions for exploratory fishing. Seeing if scientific research fishing will require further controls. You actually have fishing vessels from states go out and fish. And not even exploring. They just want to find out what's out there for scientific purposes. But that could be harmful to the environment. Actually, one scientist has said, look, you know, sponges can live up to 300 years, we estimate. It may take 3,000 years to recover. So if you're going to allow your scientific vessels to go out, shouldn't there be more controls? All it says you have to inform the other countries of your plans to go out in scientific research. Again, you know, sort out commencement of negotiations, when that should occur, what constitutes adequate scientific information, how the precautionary approach should be applied, and then fleshing out indigenous rights and interests and how those be addressed. The agreement does mention the UN Declaration on Rights of Indigenous People, but again, it's not much detail yet how that's all going to play out. At the 2023 meeting, you had the Inuit Circumpolar Council show up in 3 delegations, representatives on 3 delegations. So they're actually on the delegations in some cases, but only one indigenous group has been participating so far in the actual delegations. And then if fish stocks are discovered up there, and by the way, it's not sure they're going to be commercial fish stocks, but if they are, then I don't even want to be in the room when this comes up for negotiation, because, you know, who has the rights to fish? The indigenous groups? We don't have historical fishing up there, so how do you set up the access and allocation access rights? That's all very open to question. And one or more no-take areas might actually be benefited favored by coastal states of a case of straddling fish stocks. And the sui generis, a very special nature of the Central Arctic Ocean, could justify a unique international protective response. Let's just close it down and not allow fishing for maybe forever. Again, very controversial. Then with shipping, I'll skip over the shipping part. Let me just say that the PAIM working group under the Arctic Council has kind of put it on a pause for now. And we have a couple reports that are going to come out, including the synthesis report on status, human impacts and management measures in the Central Arctic Ocean. I'm on a drafting committee of that governance chapter. It's been paused because of the Ukraine crisis. So this report will come out maybe in the coming year or so. And we'll probably have more guidance on various governance issues that will have to be faced for the Central Arctic Ocean. And then third, very quickly, determine extended continental shelf boundaries in the Arctic. Only Norway has completed the Commission on Limits of Continental Shelf process. It hasn't actually put in place its coordinates yet under the process. Canada's made its submissions with further submission in December 2022. Denmark, Greenland's made its submissions. I won't go into details. I'll leave it to my PowerPoint. Russian Federation has made quite a few submissions, including basically in March 2021, and then a further partial revision in 2023. And then Canada, Denmark, Greenland, and Russia all claim the North Pole. Everyone wants Santa Claus to be their national, along with the reindeer. U.S. is not a part of the UNCLOS and therefore may not be eligible to submit a claim off Alaska to the CLS. I think that's overstating it. If you go back to the convention itself, it actually talks about coastal states making their submissions. It doesn't say have to be a state party. So, but again, that's in the literature. And the future then remains, again, the policy approaches of the Arctic by the future developments of extended continental shelves in the Central Arctic Ocean, mineral exploration or exploitation future, marine conservation future, or a combination. And then one last quick slide on that part, almost there, Chris. The large part of this Gackel Ridge right there might lie beyond national jurisdiction in light of the Commission recommendations to Russia submissions that the Commission issued on 6 February 2023. So we don't think that's continental in origin. It's oceanic. But then if you look at what happened, Russia came back to the state parties' Law of the Sea meeting in June and said, we're going to do additional scientific research and conduct in order to classify this ridge as submarine ridge under Article 76, where we would have the seabed jurisdiction. And future governance then remains very uncertain for that Gackel Ridge. There's already been calls maybe for a similar precautionary moratorium on seabed mining like we do for fisheries. You could have a declaration of parties. You could actually leave it to the seabed, International Seabed Authority to deal with it. It remains to be seen what will happen. And then finally, I'll just end it here on my BB&J. And I'll only give you the one example because of time. But again, how will the new agreement on BB&J apply to the Central Arctic Ocean? And just give you one example, establishment of MPAs and other area-based measures. So you can set up now MPAs through nomination from parties, of course, a review process and decision by the Conference of the Parties. However, a major constraint looms on the horizon for protecting deep seabed from mining. Establishment of MPAs and other area-based management tools cannot include areas within national jurisdiction. In light of the vast extended continental shelf claims by 5 coastal states in the Arctic, this will likely exclude most of the CAA Central Arctic Ocean seafloor. It remains doubtful that global process will be used to address regional protected areas in the Arctic, particularly in relation to fisheries, shipping, and possible mining beyond national jurisdiction. Conference of Parties must respect the competence, of course, and not undermine relevant legal instruments and frameworks and relevant global, regional, sub-regional, sectoral bodies. And Conference of Parties may recommend protective measures to competent global, regional, and sub-regional sectoral bodies. So it remains to be seen. There is actually a new NGO called 90 North Foundation that was recently established, and they're actually already pushing to protect the North Pole and the Central Arctic Ocean pretty well entirely, and they want to keep shipping down below the Central Arctic Ocean. So you're going to see NGOs come in. I wouldn't be surprised for NGOs to join with some country like maybe Monaco to actually go ahead and maybe submit. So it just remains open to see. And then I'll just say MGRs, again, is another issue there. Thanks, Ronan, for your great presentation this morning. But again, it's a big issue here. This one, to me, is where the parties may really hold off becoming party, because you can actually go ahead and exploit, collect, and then just wait it out. And then you become a party, and then you can just say, we're not going to count. You know, we don't have to deal with the provision will not apply to our previous takings. So there's a reason why countries might delay becoming party to the BB&J agreement because of the MSR provisions. And then conclusion. This is an unfinished voyage with many other unanswered questions. What is the future of the Arctic Council, and might more formalized regional cooperation, including a regional seas convention, be possible? Will the polar bear agreement be up to the task? What about the ITLOS advisory opinion? Let me just finish on that. Surprisingly, Norway and Canada both made interventions, submissions to the ITLOS advisory. They didn't mention the Arctic. I was shocked. And in fact, the IUCN, if you go on the IUCN submission to the ITLOS advisory, paragraph 141, I happen to help draft that provision. It actually says preservation of sea ice, polar sea ice should also fall under the responsibilities, state responsibilities, protect and preserve the environment, preserve the marine environment, preserve it, preserve the ice, don't let it melt. And setting national contributions under the Paris Agreement, again, they should be thinking about not just the temperature, but the whole loss of sea ice, and also the polar sea ice in Antarctic, right? It's another issue there. So again, if you look at the IUCN paragraph 141, you'll see, and go back to the Paris Agreement, it calls on protecting the integrity of the oceans in the preamble, unfortunately, but it's still there. So you put that together, to me, is a very strong argument. Countries have to begin to wake up, including Canada, including Norway, including other Arctic states. It's time to protect the Arctic. And, you know, Inuit indigenous right to be cold. There's books written on it, right? So our whole new world we live in, we have a long, long ways to go. And then you get the convene Montreal Global Framework. Again, 30% of protected areas by 2030. Again, will the Central Arctic Ocean be on that agenda? I think it will be eventually, but it remains to be seen. I'll stop there. I think I did break my record.
Thank you for that wonderful presentation. Last but not least, we have Lieutenant Commander Nicholas Monticelli joining us. He graduate of the Coast Guard Academy. As many of you know, our great friend and colleague David Caron, who Commander Coito mentioned, started off at the Coast Guard and had operational experience like these gentlemen. Nick then went to take a law degree at Berkeley and a master's degree, graduating #1 in his class at the Naval War College, widely published in national and international journals. After a highly decorated career at the Coast Guard, where he had significant operational experience, including dealing with aids to navigation, domestic icebreaking, international fisheries enforcement, search and rescue, and alien and migrant interdiction operations. So he's been out there on the water. He currently is serving as the 9th District Senior Reserve Attorney in Cleveland. For that district, he is responsible for having on call and together a nationwide deployable team of legal experts for the Coast Guard. So, Nick, thank you.
I just want to start and say thanks to Sokwu and Luis for putting everything together, and such a blessing and an honor to be here for Harry. When I was asked to speak and asked to describe what I wanted to talk about, something that we've talked about today regarding Harry, and something that came to my mind immediately, was Harry's optimism. And so his optimism for the future, we heard it today, his optimism to get the dissertation on file, that Joel's going to be an admiral, that LOSI conference is going to be in Hawaii next year. All this optimism, this eternal optimism. And even looking at the title of the program, it says emerging challenges, but Harry would read that, and correct me if I'm wrong, but as emerging solutions. Everything was a solution to Harry. There was no challenge that he couldn't overcome. And so I wanted to make my presentation based on optimism. We've heard a lot of the challenges, but I want to step back and talk about some of the changes that have come about due to Harry's scholarship and our collective knowledge and discourse and talking about the issues that really provide optimism for the future, and optimism for the continued governance, and optimism for really everything that we hold to be so important in this area. So I'm going to talk a little bit about international fisheries, because if there's ever going to be a topic at the end of the day that's going to get this group excited, it's going to be fisheries. So we're going to go with that, and let's go ahead to the next slide. So real quick, we're going to talk about very quickly some of the background. Everyone in here is familiar with the background of how we got to where we are. I want to foot stomp the inflection point of 2015 and talk about why that's so important. We talked this morning about how international law moves slowly. And so how slowly are we moving? How quickly are we moving? And what does that mean for the future as we talk about BBNJ, as we talk about the Arctic, as we talk about all these issues? Do we have optimism that we can pick up the pace? And then looking into the future, what are some of those next issues, and where are those emerging solutions going to be? And so I put two pictures up here. I have a lot of pictures and not a lot of words. So at the top right there, that is basically in the Coast Guard, our equivalent of an aircraft carrier. This is a national security asset, the biggest Coast Guard cutters we have. And it's working alongside a small fisheries patrol vessel in Guyana. This was 2 years ago. They are working on on IUU fishing enforcement. This picture doesn't happen 5 years ago. This picture did not take place 5 years ago. And so showing some of the evolution of how we are choosing to implement the frameworks and the agreements and the treaties in place, sometimes these pictures really do speak. The bottom right, the U.S. Interagency Working Group on IUU Fishing. I think the only testament to the importance of this working group is everybody knows that the politics in America are somewhat polarizing. This working group has been around through administrations and continues to do its work and continues to get funding. So it shows you just how important the issue is and will continue to be, no matter where folks are lying on the political spectrum, north, south, east, west. The issue is coming to the forefront. Next slide, please. The traditional framework, I can't believe we made it through a whole day of conference without this picture. I don't understand how we did it. I figured I had to slide it in there, but so this is really the foundation of it. And we've heard a little bit about the fish stocks agreement, right? Coming up on 30 years ago. We heard a little bit today about the RFMOs. We heard a little bit today about the tribunal's advisory opinion. And we heard about the nuance in that, the first ever advisory opinion. And so now we are 50, 60 years moving forward on some of these issues. And where are we? The state authorities, flag, coastal, and port state, how they have evolved into tackling the issue of international fisheries. I don't think that anyone imagined that one of the key authorities when dealing with IUU fishing was going to be Port State Authority. But that is how the evolution has trended. So next slide, please. It's not an issue necessarily of who has state powers. Everybody understands who, well, there could be some disagreement of what state has the powers in which area. Everybody understands what those powers are. And this is a debate that's been going on for hundreds and hundreds of years. Aside from the delimitation conflicts, I talked about the growth of the port state regime. And the port state regime really took off in the post 9/11 world. And the United States took this idea of a port state authority and grafted on top of it a whole nother level of both responsibility, authority, enforcement mechanisms, and a regime couched in security, but then transition into other areas of the law of the sea framework. And I love the small islands really taking the bull by the horns. And I pull this headline out. And right, this doesn't happen, but the Solomon Islands actually told a Coast Guard cutter that they could not pull into port at the Solomon Islands. And 5 years ago, that doesn't happen. Right? It is very unusual. I mean, this is a close ally. And the reason that Coast Guard cutter was not allowed to pull into the Solomon Islands for a port call was because the Solomon Islands did not agree with the way that the U.S. Coast Guard was conducting IUU fishing enforcement in that part of the world. So we talk about small island nations really leading the forefront. I don't know what bigger message could be sent than to tell a U.S. warship, go away, right? I mean, it's just the facts. Next slide, please. This is the RFMO framework. This is what we have, and it is a jumble, okay? And the problem, one of the problems, the way I see it with the RFMOs is the RFMOs are collections of states that provide input, but in a lot of ways, RFMOs act like states. RFMOs have their own processes. They have their own procedures. They are all different. An RFMO in the Pacific doesn't look like an RFMO in the Arctic. It doesn't look like an RFMO in the Atlantic. And so BBNJ is going to solve some of those issues by creating an overarching guidelines on how to communicate. But with everything going on with all the RFMOs, and quite frankly, the different ways that they interpret their role in their region, you have a patchwork. And at the end of the day, it's now been almost 30 years, and we've seen some are more effective than others. Next slide, please. This is if anyone's familiar with the WCPFC and how they conduct business, they publish the annual watch list, the IUU watch list. And they say, okay, these are all of the vessels in the entire region that we believe are engaging in IUU activities. There's 3 vessels on that list for 2023. When I walked into the headquarters in Pohnpei, probably 15 years ago, guess what? It was the same list of 3 vessels. And so I don't say that in a belittling way, but as in a questioning way, almost as a, how can this be? 3 vessels out of a literal sea of thousands of vessels, and it hasn't changed in 15 years. Something can be better here. Next slide. So pre-2015 versus post-2015. We've heard a little bit about this case already. I consider this to be an inflection point into how states viewed IUU fishing, how they viewed their responsibilities to conserve and preserve the maritime environment. The tribunal issued their first ever advisory opinion, and we may not see an advisory opinion again for quite some time. It shows how important this issue is. And on top of that, this advisory opinion said, hey, coastal states, flag states, you have a responsibility, an affirmative responsibility, and we will hold you to that affirmative responsibility if you come before us again on these issues. And so that was, I don't want to say the canary in the coal mine because I'm trying to avoid the euphemisms, but it really did show the cards. It really did lay everything out. Everybody knew where the tribunal sat. Next slide, please. Linked to Articles 61, 63, and 64 to say coastal states, port states, flag states, you have to work together. RFMOs, you have to work together. We see this idea pop up in the BBNJ, the same way, like you have to work together. Required cooperation. What do we want, right? Joel, I don't know, that could have been the same drug boast that the picture that you had. But I want to live in a world where we have these pictures like you have on the top left there, where that's an enforcement asset that has interdicted $1.5 billion of illegal drugs. We are not far, and this makes the news on a regular basis. We want to get to a point where that is also a regularity to see busts for illegal fisheries. And we're getting very, very close. And one of the things that has really come out since 2015. It really is quite amazing as I step back and look at the development, is one of the linchpins of any effective law, international law, domestic law, doesn't matter, is enforcement. And unfortunately, that's often the weakest part of any international law regime. We can sit here and we can come up with the best framework and the best approach and the best way to solve any sort of disagreements, but without enforcement, it means nothing. Something really isn't illegal unless you have someone on the other side to enforce and double down on defining that as illegal. After 2015, we now see a revamped and a reinvigorated focus on enforcement. Next slide, please. So in addition to just having folks focus under the idea of enforcement, which when I began to think about it, you have to have all of that other framework in place to enable states to go out and enforce those laws. And that's a testament to the Fish Stocks Agreement. That's a testament to the RFMOs, right? So you have increased resources. You have, just as the Biden administration issued a memorandum on the expanding the marine protected areas in Hawaii, the Biden administration directed about 30 to 35 agencies in the US government to start doubling down on the issue of IUU fishing and work with our partners to get this under control. On the bottom right here, you have, and it's just trivial, but I thought it illustrated the point so well. So Southcom is the United States breaks up the world into regions that the Department of Defense kind of is responsible for controlling U.S. military movements in that part of the world. Southcom is a Department of Defense's geographic distinction for all of South America, okay? All of South America. And on a podcast, right? This is a podcast from about 10 months ago. They're saying, hey, look, IUU fishing in South America, it's not about fish. This is almost a 180 from the perspective that states have taken in the past, and specifically the United States. South America was not an area we were worried about fish. And to be completely blunt, the United States is not necessarily worried about fish. The United States is worried about stabilization of countries in South America. The United States is worried about economic implications. The United States is worried about what would happen if the fish weren't there. So you've seen the rhetoric now shift, and Harry was on the forefront of this, right? IUU fishing is a national security problem, right? And so it's there now. This was not an issue 5 years ago. It just didn't come to anyone's mind, except maybe Harry's, but that's okay. Next slide, please. So looking ahead, I believe it is simply a matter of time, I would say less than a decade, when we see an ICC prosecution for IUU fishing. 2016 is when the Office of the Prosecutor came out and said, we are paying particular attention to environmental crimes. I'm not sure if the right case has come up. I'm not sure if the right facts have come up yet, but I believe it is simply a matter of time. And we don't know where that's going to go, but that's a likely next step. I think the other thing that you're going to see, the bottom right, so I showed the shaded areas of the RFMO. These are all the acronyms. It's really hard to see each one of these little lines of different RFMO. An increase in RFMO cooperation is going to be critical to implementation of BB&J. It's going to be critical to implementation of new areas and potentially new fisheries like we might see in the Arctic. And the last thing I think we're going to see states double down on are the exercise of their port state authorities. And so the agreement of port state mechanisms, the PSMA in 2016, was a solely IUU focused agreement on using port state authorities to keep IUU fishing at bay. And it really comes down to a fishing boat needs to go somewhere. They can't sell their catch at sea. Transshipment issues aside, those fishing boats need to go somewhere. As a former captain of a boat, I know you can't stay out forever. You don't want to stay out forever. You got to go to port somewhere to get everything done you need to get done. At the end of the day, by using port state authorities to establish a market control on not allowing the product of IUU fishing to land is going to be a key enforcement mechanism moving forward. And we're seeing this already. We're seeing that this was an FSM. There was, I believe, a Taiwanese flagged fishing vessel. And FSM said, you're not coming here. We believe you engage in IUU activities. You're not going to land your catch here. Go somewhere else. And if that's not a market incentive to disincentivize a behavior that we don't want to happen, it sends a very, very powerful message. And so with that, next slide. And Chris, I think I'm doing well. So, all right. I'll close it out on an upbeat note. So thanks, everybody.
A few questions folks would like. Oh, there's a great
Thank you very much. Clive Schofield, fresh in off the plane from the World Maritime University Global Ocean Institute, and it's a real pleasure and delight to be back amongst this family, this community. And family implies we may have various fights, but I think community may be better in this instance. Yeah, it's a great honor to be part of this tribute to Harry in particular. But in terms of question, and I am straight off the plane, so forgive me if it doesn't really stack up. But for Vashko, you highlighted the Bangladesh-India case in particular, the arbitration ruling. And really that, to my knowledge, is the first time that a state has really deployed arguments around climate change inspired impacts on coastlines and therefore baselines as an argument before an international tribunal. And the tribunal gave those arguments effectively short shrift and expressed the view that with the tribunal's specific purpose of delimiting a maritime boundary, the tribunal wasn't worried about where the coastline was in the past and wasn't worried about where the coastline might be in the future on the basis of projected sea level rise impacts, but only where the coastline is at the point in time it had to delimit. Is it worrying for you, Vashko, that the only tribunal that's really had to deal with that sort of argument really dismissed the issues in the context of these advisory opinions that are in the process of being underway, and whether those arguments will be similarly treated in a negative way by a rather conservative, restrictive interpretation of the law of the sea, albeit bearing in mind that the India-Bangladesh case was specifically on the issue of delimitation, and these advisory opinions are rather more broad.
It looks like we're having a duet. But thank you very much, Clive, for that question. So I think it's a two-part question. The first part, yes, I agree. Very conservative also because a lack of sensibility for the problem facing, in this case, Bangladesh and all the issues regarding receiving coastlines. But I think that regarding the second aspect, I think that courts, with exception of Nicaragua, Colombia, so far, that I think is the only exception, deal with maritime delimitation differently than they deal with any other issue. I can see, well, I really can't anticipate what the advisory opinion will look like. I was listening to Dr. Kim's fantastic presentation. What other obligations that we are not aware of at the moment can be fleshed out? I mean, also, as we saw with the issue of Daniel was mentioning, that obligation to protect the marine environment should also include to protect the ice. Is to protect the ice an obligation under Article 192, or is maintaining the ice sheets as they are now not under Part 12, but under specific obligations for ice-covered areas? So I think that fleshing out more obligations that already exist that we are aware of will be a difficult challenge, but, and this is where the issue is different from maritime delimitation, courts might feel emboldened to go further. In the case of maritime delimitation, I believe that will not be the case. And my point is that I don't see an international court tribunal advancing the envelope forward with respect to sea level rise, climate change, vis-a-vis maritime delimitation. I see that happening through state practice, not through judicial adjudication. And I believe that the work that has been done in ILA, where you and Sekou Lee and me, and we are in, and the ILC as well, dealing with other issues as well, state practice will push the envelope forward, and then that is something that will be recognized by International Court of Tribunal down the line. I don't see the process coming through there, because if it would, then we will be going back to 1969 with there's this rule, this dogma, live with it, and make a big mess for another 50 years. Sorry. Thank you. It took us 50 to solve this one. So let's not start another.
One more question, Louise.
There's one more quick question.
I have one. No.
Yeah, I just wanted to ask David if you have observed any changes in the way the Arctic Council listens to or gives credence to the rights of the Inuit people who live in that area. Have you seen any development, any increased awareness, any more recognition of their rights in the last decade, say?
Yeah, as most people probably know, you have 6, they call permanent participants. So Indigenous organizations. And so, that goes from the founding of the Arctic Council in 1996. So that's still the situation today. And, they don't have eventually voting rights when it comes down to some kind of consensus decision-making, but there's been really fully involved in all the project developments. They have to approve projects that go through the Arctic Council. So I think it's really a good sign, for the Arctic Council, almost a bright light internationally of what can be done. Coming back to your talk this morning, again, you look at the North Atlantic Salmon Conservation Organization, they were always silent Indigenous peoples, although Indigenous peoples rely on salmon stocks, for example, in the North Atlantic. And now they're looking at making observer status, special observer status next year for Indigenous peoples. Had a special session recently at their conference of parties meeting of the parties to deal with the whole question of Indigenous engagement. So I think you're beginning to see progress also even in RFMOs now in some cases. So still a long ways to go. But at the Arctic Council, I think is a gold standard in a way. It could still be better. And we'll see where the Central Arctic Ocean Fisheries Agreement goes. That's going to be really interesting to watch, because will other countries involve their Indigenous peoples? For example, the Russian Federation, they don't have a very good relationship these days. So one has to watch that. And then, not all the participants have been involved in the Central Arctic Ocean Agreement. Let me go back one thing about Canada. I don't want to give Canada a bad name. You go back to their submission to the tribunal. They actually did mention the Arctic. They did mention the idea that we have to be evolutionary in our interpretation. They did mention the Paris Agreement. The only thing they didn't connect, though, was the loss of ice, and they need to preserve ice. So that's what I was trying to get at. So I don't want to give Canada too much of a black eye, but they could have done better.
They're concerned about their lack of fulfillment of their commitment to reducing greenhouse gases, and so they don't want people to say, well, how can you say this when you're not doing what you said you were going to do, and you're a big emitter? So
exactly. But see, that's where I think we got to hold countries responsible, saying, look, when you set your nationally determined contribution, don't just think of a 1.5 degree or 2 degree ocean acidity, ice, they all go together. Get off the political agreement of Paris. We have to do better. That's essentially what it's about. And I think that's the message. And we were trying to give this message. One last thing, the Central Arctic Ocean study that's undergoing our PAM, we will see how far the academics who are writing this chapter can go, because there's been pushback already by some government officials saying, well, only describe the international law that may apply. You cannot make any recommendations or findings. So this has not been finished yet, this chapter. So again, even within the Arctic Council system and this, this special study undergoing now, we're not sure yet how it's going to come out and how far the academic voices can sound out.
What is your pleasure, Louise?
About half an hour before we have, it looks like there's a pressing question in the back corner.
Yeah.
And a question for Nicholas. So I am in the last towards the end of your outstanding presentation, you mentioned the possibility of a maritime environmental crime be taken to the ICC, but I believe that that possibility would only exist within the context of the environmental crimes we already have. And for the most recent one that probably will be taken to the ICC would be the destruction of the dam in the Ukraine by Russian forces. Let's call them what they are. But the main issue of connection with IUF in the future probably is somewhere in between the mandate of UNODC and other organizations, so outside of the realm of ICC. Would you think that would be a fair assumption? Thank you.
I do. My thought on why I believe that venue may become available to talk about this issue because of the way the rhetoric has cranked up so much that I feel that states will find a way to get the issue in front of the ICC. I agree it's not a great fit right now, and it really wouldn't go into the mold of what we would really think of, something that would go to the ICC. But looking at the rhetoric, looking at the importance that states are putting into the issue, and how that, I hate to say exponentially, but how the focus on IUU fishing as a broader concern has become so important to a lot of states that that care very deeply for the issue. I think it's going to make its way there in one form or another. I really truly do, just because of the increased importance. But I agree, it might not be the first stop. Might not be the first stop.
Great. Well, thank you, everyone. We do have a lot of time set aside tomorrow for also more discussion. So hopefully we can continue some of those conversations. We're going to close up today with some special speeches that Sherry Broder is going to introduce. And then, so I don't have to come back up here again when we wrap that up. So no one has to listen to me again. There will be cocktails out here on the patio, and then they'll set this room up for dinner. So we can all take a little break, be outside, and then come back in for dinner.